Welcome to Employment Law class. Today we look at Section 6 of Unit 5, Termination of Agency. Session Objectives. By the end of this session, you should be able to identify the ways for termination of the agency relationship, explain the effect of termination on the agent authority. Now, termination of agency relationship. Once the two parties came together to agree that one person is the principal, one person is the agent, it is the same way that they can bring that relationship to an end. So by agreement, agency relationship can come to an end by the act of the parties. So you are saying that if the agent perform the duty, the agency has come to an end. If the principal also revoke the power or authority given to the agent, it has also come to, agency relationship has also come to an end. You also indicate that renunciation by agents. An agent is entitled to renounce his power by refusing to act or by notifying the principal that he will not act for the principal. So here, what you are saying that the agent, if he's not interested again, will come and tell you, look, principal, the work that you have given to you, I will not perform it again. Once he communicates his intention or he renounces the power that you have given him, the agency comes to an end. The other way you can terminate is by notice. You give the person notice of your intention not to continue. You can also terminate agency relationship by operation of the law. Operation of the law here, looking at an agency may be terminated by the operation upon the occurrence of particular event. So operation of the law, in the case of individual, you concern the issue of insanity. So where the principal appoints an agent to perform certain acts on his behalf, and the principal dies, the relationship has come to an end. So A appoints B as an agent, and B died afterwards. The agency has come to an end. Insanity. A appoints B as an agent. Along the line, A becomes insane. The agency relationship between A and B has come to an end or has been terminated. Bankruptcy. Bankruptcy occurs when a person cannot pay his or her debt when they fall due and the court has pronounced him bankrupt. In that case, if the principal has been pronounced bankrupt, the agency relationship will come to an end. In the case of company or limited liability company, it comes to an end when there's winding up. Winding up simply means that when a functional body corporate ceases to be a functional body corporate. In simple terms, when a going concern company ceases to be a going concern, that in the process of bringing the company to an end. Receivership. When a company is winding up, the appointment of receiver brings agency relationship to an end. So one of the effects of winding up would state that upon the appointment of the liquidator, the powers of directors are being taken away. So directors will no longer act as an agent for the company. That's receivership. Or in the case of charges, when a floating charge holder or floating charge crystallizes into fixed charge, a receiver is appointed. A receiver is appointed to ensure that the goods are in the hands of, the goods are sold to pay the floating charge holder. So by way of receivership, once a receiver has been appointed to ensure that the property of the company are being sold. The officers of the company will not have the power to deal with those particular goods in question, and therefore they cease to be agents, and therefore the relationship between officers of the company in relation to that property will be terminated. Another one you can think of is frustration of the contract of agency. When there's frustration, the relationship will deem to have come to an end. Now, what is the effect of termination of agent authority? Once an agent is terminated by any of the means that we have discussed, it brings the agency relationship to an end. So it brings everything to an end. However, ex-agent, as past agent, may retain apparent authority to bind their former principal. So with this one, because a third party doesn't know that you have stopped performing or acting as an agent for your principal, the principal will still be bound by the contract entered into by the ex-agent with a third party. However, the third party who are unaware of the termination may reasonably believe that an ex-agent still have authority. So, as you are saying, if he's not aware, the caveat is that if he's aware, then the third party will not be bound by it. An agent's apparent authority often persists after termination, and there is therefore the need to protect the third party. That's why the principal will still be held liable. However, if the third party is aware, then the principal cannot be held liable. Now, apparent authority ends only when the third party receives appropriate notice. So, the apparent authority of the agent will end when he receives appropriate notice of the termination. That is when it is no longer reasonable for a third party to believe that the agent has actual authority. So for that, as I was saying, if he has knowledge that you are no longer an agent for the person and he go ahead to transact, he will bear his own, he do it at his own risk. For a third party who have previously dealt with the agent or who have begun to deal with the agent, actual notification is necessary. So you give notification to the third party that, look, this particular person is no more an agent to me, so don't deal with him in case he comes with my name. So this is accompanied by a direct personal statement to the third party. So you make a direct statement to the party, or you deliver to the third party personal write. You write and deliver to the third party, either personal or to his workplace. So you write. Either you write or you communicate it to him personally. For all other parties, constructive notification should be given. So sometimes you give constructive notification. Constructive notification normally can be accomplished by advertising the agent's termination in a newspaper of a general circulation in a place where the agency business regular was carried out. So if the person is not just a newcomer or any other person, you try to publish the person's name in the newspapers so that they will not deal with it. The typical example you can find is, you see, normally when the banks terminate the appointment of their staff, especially when the officers conduct themselves in fraudulent manner and they sack them, they will put in the newspaper that this person does not work with us, so you transact with him at your own risk. Summary. By way of summary, we have attempted to explain what termination of agency is and the ways in which termination of agency can be done. We also look at the effects of termination of an agent's authority.